Well, the Supreme Court just basically legalized money laundering by rich campaign donors, as Ian Millhiser says over at the Center for American Progress's blog, Think Progress. And, I was sort of hoping that I could have a conversation with Dan Backer about if we're not going to stop corruption of our political process by rich people by virtue of regulating money, then how do we do it? But I never really got an opportunity to ask that question, and I think that his answers to every question that led up to that indicated that he didn't have an answer to that question. Although he's not here to speak for himself, so I don't know. Maybe he does. But it's looking at the arguments that are made. And by the way, he is right. That was just absolutely brilliant to get John Roberts' clerk to argue the case. A young woman at that who because you've got now 3 female justices on the court, although her arguments were not persuasive to the women on the court. But it just, slick stuff. And they, they're very proud of themselves. And America is now becoming a plutocracy. This, to me, says so clearly that we all need to be doing 2 things. One, supporting candidates whose first and foremost commitment is to get money out of politics. The only one that I know of right now who is overtly supporting the Move to Amend effort, which is all corporations are not covered by no corporations are covered by the 14th Amendment, no money is covered by the First Amendment, is Marianne Williamson. She's running for Henry Waxman's old seat out in Los Angeles. And MarianneForCongress.com, I think, is her website. And, we need to be supporting candidates like that. And number 2, we need to be part of a citizens' action movement to say, okay, if the Supreme Court is going to say, over the years, back in the 1870s, there was a woman by the name of Sarah Bradwell who passed the bar in Chicago and walked into a courtroom one day and said, I'm a lawyer, I've passed the bar, got my license, and I'm here to argue on behalf of my defendant, Joe Blow, or whoever it was. And the judge looked down at her and said, you are a woman. You may not argue in my courtroom. And Ms. Bradwell said, I don't think so. That's not, you can't do that. And the judge said, I just did. You're out. So she sued. It was Bradwell versus Illinois, as I recall. So it must have been a state court. And she took this all the way to the Supreme Court. And I don't have a copy of Unequal Protection. Can somebody toss me that right there? It's right in front of the clock. Because I have to read this language to you. It is so mind-boggling. And this is just an example of how wrong, Shano, thank you so much, how wrong the Supreme Court can get things. Let me look this up in my own book, right? Bradwell, B-R-A-D, Bradwell v. Illinois, page 53 and page 320. Let's see if page 53 has it. Here it is. The Supreme Court in 1873 in Bradwell v. Illinois, Justice Joseph P. Bradley wrote the opinion for the court. And he said, and I quote, basically he said to her, no, you can't be a lawyer. Or you have no right to be a lawyer. He said, and I quote, the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. So firmly fixed was this sentiment in the founders of the common law that it became a maxim of that system of jurisprudence that a woman has no legal existence separate from her husband, who is regarded as her head and representative in the social state. That was 1873. The Supreme Court said women have no rights outside of those provided to them by their husbands. In fact, they couldn't execute a will. They couldn't sign a contract. They couldn't own things. If their husband died, a man was named as the executor of their estate, and he took a third of the estate for doing the job. and he could decide what happened to her children. She could lose her children. Women had no rights. And so how did we get around that? In 1920, we all got together and said, screw this. We're going to overturn the Supreme Court's Bradwell v. Illinois and other decisions like it. And we're going to assert that women have equal rights with men, including the right to vote. And that was the 19th Amendment passed in 1920 or the 20th Amendment passed in 1919? I get them mixed up, but it's one or the other. I'm pretty sure it's the 19th Amendment passed in 1920. Actually, I have a Constitution here. I can look it up. But the point of the matter is that the way you get around a bad Supreme Court decision is by amending the Constitution. The Supreme Court in 1856 in Dred Scott ruled that people are property. Slavery is totally just fine, thank you very much. We fought the Civil War, but that was still the law. So how did we overcome a bad Supreme Court decision? We did it by passing the 13th, 14th, and 15th Amendments. The 13th Amendment explicitly outlaws slavery. The 14th Amendment explicitly says you have equal protection under the law regardless of your race and regardless of your previous position of involuntary servitude. In other words, if you were a slave. And the 15th Amendment says you have the right to vote if you were a slave. If I'm recalling correctly. Yes, thank you. Shane is nodding. He's our expert in all things constitutional. So, I mean, this is... Okay, here's that's suffrage in the District of Columbia is the 23rd Amendment. Yeah, it's the 19th Amendment passed in 1920. There we go. Interesting. When was this thing proposed? Yep, it was proposed on June 4th, 1919, ratified August 18th, 1920.
You're listening to the Thom Hartmann Program. Call 866-987-THOM.
So we have no shortage of examples of when the people have gotten together and said we're going to pass a constitutional amendment to undo some idiot thing that the Supreme Court did. We need to do it again.